Good morning to all of you, and welcome to the next episode about the Conference of the Future of Europe episodes. So today I will replace my dear colleague, and we will be focusing on the discrimination in the EU, more exactly about the prohibition of discrimination. So I will let my two dear colleagues present themselves.
Thank you, Laetitia. So hello, everyone. My name is Julie Serratani, and this is Héloïse André. We're both students in the international and European law at the University of Lille. Today we're going to talk about the ferocious combat that the European Union is leading against discrimination in all aspects of our society.
Okay. Could you please explain us those values that the Conference on the Future of Europe are invoking?
Yeah, of course. There's various topics that will be evoked during the Conference of the Future of Europe, but we chose to approach one specific ones: the values, rights, the rule of law, and security. So indeed, the rule of law is one of the founding principles of the European Union. It guarantees the respect of fundamental rights and values through which the EU law imposes its member states their compliance. The EU seeks actively to protect human rights, combat discriminations of different natures, and to promote equality, with, for instance, the prohibition of discrimination on the grounds of sexual orientations, which I will be covering today, and on the grounds of race and ethnic origins, which Héloïse André will present.
Welcome.
Thank you.
So one of the questions of the Conference of the Future of Europe is: how can we fight discrimination and promote equality to ensure our rights are guaranteed? Could you maybe clarify this for viewers?
So firstly, we can talk about a legal framework to fight against discrimination and promote equality. So firstly, this can be demonstrated in, for example, the treaties of the EU. So under Article 2 of the Treaty on the European Union, it is stated the values of the EU, which are, amongst other, the respect of human rights and non-discrimination. And so every single one of the EU member states have this obligation to uphold these values that are laid out in Article 2, and this is only reinforced, for example, in Article 10 of the Treaty on the European Union, which establishes the democratic principles of the European Union. And furthermore, under the Treaty on the Functioning of the European Union, under Part 2, it addresses the importance of non-discrimination, which is our topic today. And so Article 19 of the Treaty on the Functioning of the European Union explains that the Council may take appropriate actions to combat discrimination based on sex, racial or ethnic origin, which I will be covering, religion or belief, disability, age or sexual orientation, which Julie will be covering. So moreover, we can also talk about the Charter of Fundamental Rights of the European Union, which only serves to bolster these treaty provisions, such as Article 20 and 21 of the Charter, which addresses the notions of equality and non-discrimination. So more specifically on my topic concerning the discrimination on the grounds of race or ethnic origin, the legal framework will rely on the Racial Equality Directive of 2000 and the Council Framework Decision of 2008 on combating certain forms of expressions of racism and xenophobia by means of criminal law.
What about usually? How can this be approached from a discrimination point of view when considering sexual orientation?
Well, discriminations on the grounds of sexual orientation has been approached in numerous ways. Indirectly and directly through, for instance, treaty provisions, as Héloïse has just mentioned, also through strategies such as the LGBTIQ plus strategy of 2000 to 2025, where the Union strives to celebrate diversity as a part of the collective richness of the European Union, allowing individuals to be themselves without the risk of discrimination, exclusion, or even violence. I would like to specifically talk about two important directives that were elaborated in the year 2000s. They were adopted on the basis of Article 13 of the EC. The first one is the Race Directive, as prior mentioned by Héloïse, while I'll be focusing and addressing the Employment Directive, also called the Directive 2000/78/EC. Both cover discrimination on grounds of religions, belief, disability, age, sexual orientation, or even ethnic origin. What I found really interesting is how the directive scopes has been enlarged by the Court of Justice of the European Union throughout the years.
Great, thank you for those precisions. Julie, which case law could complement this legal framework that you were referring to?
Well, I wouldn't be able to tell you all the case laws because have been so many throughout the years. I mean, 20 years in the making. But the ones I chose to focus on that complement the legal framework, especially the Directive 2000/78, I chose to specifically look at one case that was rendered on April 23rd, 2020, under the name of NH versus, excuse my Italian, I do not speak it, Associaciones Avvocature per i diritti LGBTI, to be quite interesting. Indeed, there has been an enlargement process, as I've mentioned, to give more protection to individuals and to give a broader discrimination grounds. This particular case stems from two prior judgments, the Associa Accept and Fair cases, which came to clarify actually the directive. And I thought it was quite important to specify some of the specifics of the case. So it's concerned two parties, NH, who was a senior lawyer in Italy, and an association that was represented by Riet Leford, that defends actually, this association defends the rights of the LGBTQ community. The litigious event took place in 2013 when NH went and expressed during an interview on the radio that he would not wish to recruit homosexuals individuals nor to use their services of such persons in his law firm. This is quite shocking considering the age of 2020, and it actually led to a strong comment from the association who brought proceedings before and against NH. Since it considered that it constituted a direct discrimination on the basis of the employment directive. But this actually went to the Cour de Cassation of Italy, where it actually struggled to answer this case, and it it made a reference to the CJEU concerning first the locus standi of the association and whether it could actually represent and be part of the case, and secondly the material scope of the statements that could be used. It was overall a kind of case concerning the equilibrium between freedom of speech and also the freedom to not be discriminated against. Overall, what the CJEU confirmed is that it was asked to interpret, once again, like in the prior judgments Associates Accept, to interpret and examine the terms in which it could properly prohibit an homophobic speech. Ultimately, there was three things that came up from this judgment. It considered, first of all, that the association did have locus standi and that it could actually be represented before a court. It also considered that the statements made were discriminatory and were proportionate because regarding the aims of the objective of the directive. It then established that the directive to be an expression of a general prohibition, and laid down in Article 21 of the EU Charter of Fundamental Rights, and it provided three conditions to take into consideration when determining whether the link between statements made and the conditions for access to employment and occupations. So overall, the judgment has truly been seen as a sequel from prior judgment of Associa Accept and the Fair cases, since the three of them confront homophobic speech and the scope of the Directive 2078. The 2000 case 20 provided some clarifications for the prior judgments. It provided a substantive equality for LGBTQ individuals, since the court seemed to lean forward the right to be free from discrimination on the grounds of sexual orientation.
Thank you. We will make sure to remember those cases. Mm-hmm. And if I may, your Italian wasn't that bad. So, Eloise, could you maybe mention some other case law which were reminded in front of the Court of Justice? Court of Justice of the European Union, or maybe the European Court of Human Rights?
Of course. So indeed, there's as well several cases that refer to the violation of the prohibition of discrimination on the grounds of race or ethnic origin. So, for example, we have the Chess case, which was presented in front of the European Court of Justice the European Court of Justice, and it involved a Ms. Nikolova who actually lodged an application with the Commission for Protection Against Discrimination in Bulgaria. And so in this complaint, the applicant said that the electricity supply company, so the ČEZ company, so ČEZ case, was installing electricity meters at a height which was higher than other districts because of a discrimination on the basis of nationality, because as most people in the specific district were from Roma origins. And so the Court of Justice of the European Union in this case held that the concept of ethnicity had its origin in the idea of societal groups marked in particular by common nationality, religious faith, language, culture, etc. And so likewise, there were actually other cases brought in front of the European Court of Human Rights as well, such as the Timichev case or the Nachova and others versus Bulgaria case. So specifically in the Timichev case, an applicant which was of Chechen origin was refused entry into the country of Russia because he was Chechen. The European Court of Human Rights judged that there was a violation of this prohibition of discrimination on the basis of ethnic origin, and because of his Chechen origin, he had been refused entry, so there was this violation. So according to the ECHR as well, or the European Court of Human Rights, in the Nachova and others versus Bulgaria case, racial discrimination is a particular affront to human dignity and requires from authorities special vigilance and vigorous reaction. So all of these cases are just there to show that there have still been violations of this prohibition of discrimination on the basis of race or ethnic origin.
Thank you. So with all these cases in mind, how is the EU encompassing various aspects of discrimination and its prohibition?
Well, in my humble opinion, I think that the EU is encompassing various aspects of discrimination, as mentioned by Eloise, since it seeks to provide a general prohibition against it. It tries to provide through its treaties, a general prohibition against it. For instance, with my case, with the LGBTI individuals and community, the EU tries and seeks to protect their rights and in all aspects of society, whether it be publicly or privately, being outside their home, being able to express their love for their partner without being discriminated against, and also privately in private institutions, for instance, at their employment. For instance, in the case that Prior mentioned, it required the member states to be compliant, of course, with the directive through their national legislation, but it actually also encourages the member states to go beyond that directive and to protect rights of these individuals through their own initiatives. So, and as I said, it granted the association whose aim is to protect this community and protect locus standi, allowing it a broad access to the EU courts and for the enforcement of the obligations of the directive. So in my opinion, the European Union is trying through different aspects and different manners and different initiatives to fight against discrimination. But unfortunately, we can see as today that even through research, there's still a lot of discrimination in many aspects of society. And I think the European is showing its good faith by trying to implement and by talking about it with the conference, for instance.
Well, unconsciously, it's a sad reality that it's still part of our everyday lives. But lastly, I have a question about state liability. How is actually the EU holding states liable for a breach in the protection against discrimination?
That is a very good question, Letitia. So the EU can hold state liables through the infringement procedure. So under Article 258 of the Treaty on the Functioning of the European Union, so the Commission can send letters of formal notice to countries that have breached treaty provisions, basically. So I'm going to use an example. So the June 2021 infringement package. In this infringement package, the Commission sent letters of formal notice to 3 countries: Greece, the Netherlands, and Lithuania, because each of these respective countries actually had not transposed or not fully transposed the 2008 framework decision, which I mentioned earlier, on combating certain forms and expressions of racism and xenophobia by means of criminal law. So, for example, for the Netherlands, the Commission was reproaching them that they did not criminalize hate speech, which was laid out in the framework decision, the 2008 framework decision. As for Lithuania, same thing. They did not criminalize hate speech and hate crime, and Greece likewise. And this was a problem because that meant that the framework decision was not fully or accurately transposed into national law.
So, Eloise, do you think this is enough? Do you think the EU is doing enough when fighting against discrimination?
Well, there is indeed an evolution in the EU legal framework with regards to the prohibition of the discrimination on the grounds of race or ethnic origin. So in the fundamental treaties, in the charter, there are several provisions attempting to prevent such a discrimination. So as well, prior to the Conference on the Future of Europe, there were several legislations adopted, such as the 2008 framework decision, and also some framework decisions that were more pertaining to sexual orientation, to Julie's topic, that aim to fill the gaps in the previous legislations in order to guarantee a more extensive protection of such a prohibition of the discrimination on the grounds of race or ethnic origin or sexual orientation. So furthermore, we mentioned several cases brought to the European Court of Justice, the European Court of Human Rights, which emphasize these breaches of such a right and actually reinforce the fact that this should be remedied and should continue to be remedied. Therefore, all of these EU legal measures and different discussions on this topic could to some extent allow for greater protections of citizens and that are suffering from such a discrimination. Thank you.
Thank you. I think that our session comes to an end. So thank you, Eloise. Thank you, Julie. And thank you for all this insight on the EU legal framework in the fight against discrimination. And we will see you soon in the next topic to discuss further about the Conference of the Future of Europe. Thank you.
Thank you.